being costly to administer. And my Assistant Minister, Deputy McClinton, did actually cover some of the areas where curatorships have been a problem in preserving wealth to the detriment of the enjoyment of the life of the actual person that they were looking after. Of course, it is a balance. You have to have that balance. We've got the regulations to do, and I did listen to the Senator when she made comment at one of our consultations at the Town Hall. It does seem to me we want to keep the system simple in terms of how people manage and safeguard wealth, but it does seem to me that we should have accounts, but they should be available for inspection. They shouldn't have to be filed every year. And there's a very sound reason for that. If a husband has lost capacity and the wife is running the household, they find it very infuriating at the moment. They have to go to the curator to purchase something. The wife should be allowed to, if she's been granted that right to do it properly, but to also keep records. So Deputy Martin, I think some of the points that she raised was covered by the Deputy of Trinity, but we have the right now to refuse treatment, and I certainly have a view myself as to which treatment I would accept and which treatment I would not. But the problem comes if I don't have either the capacity or I'm unconscious, so therefore don't have the capacity for my wishes to be carried out. And the Constable St. Peter's mentioned one case where his brother chose not to take treatment. I had two friends who were diagnosed on the same day with the same cancer. One chose to take all the treatment going. The other one declined the treatment. They died on the same day. But I do know which one had the best end of life. But that is a matter of choice, and people should have the right to make that choice, and they have the right now. This law actually helps people in the event that they lose capacity, that they would continue to be respected in the way that they would want to have been had they had that capacity. So the advance decision is about a living will, if you like. Sorry, the Constable St John asked a question about curatorship and wealth, but if I haven't answered it, I'll come back to that. I think, Deputy Lewis asked a question about age, and it's the same question as yesterday, really, that came from the Deputy of St John, and that is that we spent a long time looking at this, something I challenged on. Actually, I challenged on whether, in certain circumstances, it should have been lower than 16. And as we know, Gillett Law has, in the UK, has approved that it should be lower in certain circumstances. We spent a long time talking about this and challenging whether 16 or 18 or whatever age it should be. But it does seem right that a 16-year-old, who, after all, as I said yesterday, has the right to consent to sexual intercourse, has the right to vote, should have the right to determine what treatment that they will have or will not have, providing they have capacity. 18 for all other things. I listened with interest to Deputy Tadea, and I agree with him that more creative thinking is required in some areas, that there's no doubt that routine and having a purpose in life does keep us bright, but of course the lack of that isn't what causes dementia. The lack of that is what gives us a lack of focus in the day. Dementia is an entirely medical condition. I think I've covered most of the points. The point is that this is not about the state intervening. The point is this is about people being supported when they don't have capacity. But as time goes forward, that people would have made it quite clear in advance what they wish to happen in certain circumstances. So the state input will be less and less if we get this right, sir. I think I've covered all the questions, but if I haven't, happy to pick them up now, sir.
Those members in favour of the
appel,
principles,
please,
the appell's been called for. Ask members to resume their seats. And ask the greffier to open the voting. I think all members have had the opportunity to cast their votes. Ask the greffier to close the voting. And the principles are adopted. 37 votes per, no votes contra. Deputy of St. 1, does your panel wish to scrutinise this?
No, sir, we do not. We give it our full support, and we are likely to scrutinise the regulations that will follow, but at this stage, no, sir.
Very well, Minister, how do you wish to proceed with the articles?
I am going to apologise to members, but I think this is too important just to say, well, en bloc, we'll do the whole lot, because I know that there are some articles that members would like specifically to take a look at. But this is new law. This is not just adapting something. So I hope people will bear with me, and I'll work my way through, sir. So starting with part 1, and I did spend some time this morning seeing if I could reduce this so that I'd still maintain the integrity of what we're doing today, but I'm afraid I couldn't. So I hope members will bear with me. Part 1, sir, the Capacity of Self-Determination Law makes provisions for individuals who lack capacity, and in particular to provide for circumstances in which the procedures by which certain decisions may be taken in relation to or on behalf of such individuals. It will establish a new regime of assessments and authorisations for the proper care and management of people. Article 1 gives general definitions. Article 2 deals with the persons to whom the law applies and provides that powers exercisable under the law in respect of a person who lacks capacity to make a decision, and that it should not be exercisable in respect of a child under 16. Article 3 states that the overarching principles to which regard must be had by anyone applying the provision of the law. Articles 4 and 5 of the law set out a simple test to be applied when assessing a person's capacity to make a decision. The test is decision specific, sir, and time specific. So what we mean by that is in some cases, people lose capacity for the rest of their life. But in some cases, people lose capacity for a period of time. So the person must have the capacity to make a particular decision on a particular day about aspects of their care. But if they do not, then we may make that decision for them. Under this test, no one should be labelled as incapable or incapacitated as a result of the particular medical condition or diagnosis, whether it is permanent or temporary. Lack of capacity cannot be established merely by a reference to a person's age, to their appearance, or any condition or any aspect of the person's behaviour which may lead others to make assumptions about capacity. Moreover, the foundation for the law is that it should be assumed that a person aged 16 or over will have the capacities to make decisions for themselves. Article 4, brackets 1, provides for the purposes of the law, a person lacks capacity in relation to a matter if there is evidence that the person is unable to make a particular decision at the time the decision needs to be made because he or she has an impairment or a disturbance in the functioning of the mind or brain, whether permanent or temporary. Article 5, brackets 1, provides under the law that the person is unable to make a decision for themselves if they are unable to understand the information relevant to the decision, to retain that information, to use or weigh that information as part of the process of decision making, or to communicate his decision, whether by talking, using sign language, or by other means. So a person should not be regarded as unable to do any of the things mentioned in Article 5.1 unless all practical steps have been taken to ensure that the person can make the decision for themselves or cannot make the decision for themselves. For example, before deciding that a person is unable to understand the information relevant to the decision, the person should be given the relevant information in a way that is appropriate to his or her circumstances, using simple language, using visual aids, or using any other means. Also, evidence that a person may make an unwise decision, which I think comes into Constable St. Lawrence. An unwise decision will not in itself be evidence that a person lacks capacity to make a particular decision. If a person does not have the capacity to make a particular decision, then before the act is done or decision made on their behalf, the person who proposes to make the decision should be established in what is in the person's best interest and act accordingly. Article 6 of the law sets out the particular matters that must be considered or disregarded by a person who proposes to make a decision in the best interests of a person. The person making the decision must not make it merely on the basis of a person's age or appearance or condition or behaviour, but should consider all the relevant circumstances and, where it is reasonable and practical to do so, encourage the person to participate as fully as possible in the decision-making process. The best interests of the person should be determined with consideration, and in particular to whether it is likely that the person will at some time have capacity in relation to the matter in question, and if it appears likely that he or she will, when that is likely to be. It's also consider the person's past and present wishes and feelings, which may include any relevant written statements made before he or she lost capacity. Should consider their beliefs and their values that would be likely to influence his or her decision, and any other factor that he or she would be likely to consider were they able to do so. The law also states that a person proposing to make a decision on behalf of someone else must, if it is practical and appropriate, consult them, to take into account the views of the following persons as to what would be in the person's best interest. That would be anyone named by the person as someone to be consulted on the matter in question or on matters of that kind, anyone engaged in caring for the person or interested in his or her welfare, anyone who has a lasting power of attorney granted to them, which applies to the decision in question, or any delegate or any other person appointed by the Royal Court to handle their affairs. Excluded decisions, sir. Some types of decisions should never be made by another person or a court on behalf of another person who lacks capacity. This is because these decisions or actions are either so personal to the individual or because other laws govern them. Article 7 of the law specifies the nature of such matters, which would include decisions relating to marriage, to civil partnership, to divorce, sexual relationships and voting. In addition, they will include decisions that may be made about treatment for mental health disorders, where someone is being detained and treated under the yesterday's debated mental health law. So acts in connection with care and treatment, as well as protecting the right of people who may act capacity. Article 8 of the law provides people making decisions about a person's care or treatment with greater legal protection, provided that they have taken reasonable steps to establish whether a person has capacity and reasonably believes that they don't. Also, that they reasonably believe that a particular course of action is in the person's best interest. When the person making a decision on the person's behalf has complied with the law with respect to assessing capacity and best interests, then they will incur no liability for their action by virtue of the lack of consent to them. They may still be liable in the normal way for any loss, damage or negligence in the way that they do not act. This could cover actions that might otherwise attract criminal prosecution or civil liability if someone has to interfere with the person's body or property in the course of making proper care to a person lacking capacity. Article 9 deals with the potential liability of a person for acts done in connection with care or treatment of the person lacking capacity, and Article 10 describes the circumstances by which payments may legally be made on or behalf of a person lacking capacity. So I ask the Assembly if they will approve Articles 1 to 10, which is Part 1 of the law.
Are the articles seconded?
They are indeed.
Does any member wish to speak on Articles 1 to 10? Deputy Bree.
Thank you very much, sir. Perhaps I am not reading this correctly, but I would hope the Minister would be able to clarify something. Once a decision has been made by the appropriate body that somebody is lacking capacity and therefore requires state intervention, is there any appeal process against that decision by either the individual who has been classified as lacking capacity or the family of that individual?
Does any other member wish to speak on these articles? Councillor St Lawrence.
Thank you, sir. I've heard what the Minister said. I just want him to confirm, looking at Article 6, that this cannot be used by agencies who don't like someone's lifestyle choice to try and prove that capacity is lacking in the individual who makes that lifestyle choice. It can't be used to interfere if there is no indication that capacity is lacking. I think does the Minister understand what I'm trying to say? Good, maybe that's more than I do. But I'm sure he will be able to give me a clear and concise answer to my inconcise question. Thank you, sir.
Does any other member? Deputy Grivell.
Thank you, sir. I'd just like to explore the idea of living will. If, for example, there have been dementia in a family, and as some of us know, that can take many, many years before that person meets their maker. But if whilst they had the capacity, they were to leave a living will and they would not want to remain in a state where they were incapable of looking after themselves, they had no quality of life whatsoever, and it was just a case of waiting. If they had given a will to say, and I think one of the only places that they can go to Switzerland, where euthanasia is legal. I just don't understand how and if they would be supported in that. Obviously not here, but a bit like the Constable of St Lawrence, it's quite a hard thing to explain, but they had left a living will when they did have the capacity. They could sort of see the signs of what was happening to them, and they would want to bring about a timely, peaceful end to their own lives. How is that supported? Thank you, sir.
Does any other member wish to speak on these articles? If not, Minister?
Thanks. I deal with the Deputy of Greville's question first. Fundamental to this law is that the person acting on behalf of another person cannot carry out an illegal act on their behalf, even if the person with capacity had asked them to do something illegal, i.e. It is illegal to end somebody's life, sir. So that cannot be done even if the person expresses that wish. So that may not be the answer the Deputy wanted to hear, I don't know, but the person who acts on behalf of another person does so in their best interest, but also within the law of the land. I had hoped that I'd satisfied the Council of St Lawrence that, and it is a difficult one to get one's head around, because the fact that somebody chooses not to wash or chooses to stay up all night and sleep all day may be alien to some of us, but a person who has capacity has that right to make that decision. It's only really if it has a detrimental effect on them, and even then they have the right to make that decision if they've got capacity, if that makes sense. I would suggest it would be looked at if it was having a harmful effect on somebody else, so a neighbour or whatever. Deputy Bree, there is an appeal system. There is an appeal system, but we'll get to that later. Okay, thank you, sir. So I ask members to for the appel on that, sir, on those articles,
The appel has been called for.
1 to 10.
On Articles 1 to 10, I ask members to resume their seats. And I ask the greffiers to open the voting. All members have had the opportunity to cast their votes. That's the greffier to close the voting. Articles 1 to 10 are adopted. 36 votes per, no votes contrary. Minister.
Thanks, sir. We do parts 2 and 3 next, sir. And these are part of the law that pertain to future planning. The importance of self-determination under the law is reflected in the provisions made to ensure that everyone who now has capacity can plan for a time when they may lose capacity. This planning takes 2 forms, sir. A lasting power of attorney, to be referred to within the law as the LPA. This can be made under Part 2 of the law to determine who is entitled to make types of decision for a person, including in the event that he or she loses capacity. So, and the other part, an advanced decision to refuse treatment, can be made under Part 3, where a person with capacity who does not want to receive particular treatment in the future in the event that they should lose capacity. So the lasting power of attorney, which is, as I say, which is referred to as the LPA, is Article 11, Part 2 of the law. The nature and definition of the lasting power of attorney will allow a person who is 18 years of age or over, so that's where I think some of the confusion comes in, Deputy Lewis is asking. For a lasting power of attorney, you have to be over 18 to determine what, whether you, as long as you have capacity, to determine what treatment you want, you can do that at 16. So I hope that's clear to the Deputy. Okay. Article 11, the nature and definition of lasting power of attorney will allow a person who is 18 years of age or older to appoint another person to make decisions on their behalf. Definition, Article 12 defines how people are appointed to the role of lasting power of attorney, and in order to make a valid LPA, the donor would need to have the capacity to make that decision to appoint an attorney when they complete the form to appoint the attorney. Article 13 is made in accordance with Part 1 of the schedule, the execution of the lasting power of attorney, and is to be registered in accordance with Part 2 of the schedule, registration of lasting power of attorney. An attorney will have the power to make decisions on behalf of the individual in their best interest. The law outlines the types of LPA. Articles 14, 15 and 16 are the sort of person that they can make. The types of LPA they may choose to make. The types of LPA, so that's a lasting power of attorney, under Article 14 are health and welfare, under Article 15 are property and affairs, and under Article 16 general matters. So I think this is one of the benefits when moving away from the curatorship where the whole lot was done by one person. So very often it was about preserving the asset rather than the health and welfare of the patient. The health and welfare of an LPA will allow the attorney to make decisions about things like the daily routine, eating, drinking, what to wear, medical care, moving into a care home, and life-sustaining equipment. This wouldn't have any practical effect until the donor loses capacity to make their own decision. A property and affairs LPA will allow the attorney to make decisions about the donor's property and financial affairs, such as paying bills, applying for and collecting benefits, disposing of assets. This LPA could potentially be used whilst the donor still has some capacity if permission is given in the LPA for that to happen. The attorney may be appointed to act alone or may be appointed so they must act jointly with other attorneys, such as son and daughter could be working jointly, or it can have more than one attorney, and they can act individually. A person may, as I said, appoint more than one person as an attorney and sometimes allow them to act separately. The donor can also stipulate that there are other matters which, in respect of which an attorney must act jointly. So you could have a combination of can act individually on some things and must act jointly on other things. So the 2005 Act contains provisions relating to lasting power of attorney in sections 9 and 14. In practice, an application in the UK for an LPA needs to be witnessed, and once the LPA has been completed, an application needs to be made to the Office of the Public Guardian, a statutory body in the UK to register LPAs. In the UK, it costs £110 to register an LPA and £220 if a person wishes to register both health and welfare and property. Further, as the forms used to appoint attorney and register in LPAs are complex in the UK, it is often the case that the person in the UK will need legal assistance in order to complete the process. So there is evidence that in the UK the complexity and the expense of registering an LPA has had a negative effect on the number of people using them. As far as it has been possible to do so, the law and subsequent subordinate legislation that might be made under it, we have sought to streamline the process for making LPAs and will make it sufficiently simple so it can be completed by most people without necessity for legal advice. However, it is also important that there is sufficient formality to ensure appropriate safeguards are in place. The law requires that any LPA must be set out in the form prescribed by the Minister by order and registered with the Judicial Greph. In accordance with the requirements set out in the schedule to the law, before it can come into effect, the LPA must be registered by the donor or the attorney. But the requirement to register an LPA affords an important opportunity to challenge or resolve disputes about an LPA and may save time and expense in the long term. Proof of a registration of LPA would also provide certainty to those who transact with an attorney on the donor's behalf. The administration costs to the Judicial Greph may be passed on to those making LPAs by making a requirement that an application be accompanied by a fee. So the level of that fee will be prescribed by the Minister by order. It is intended that the form for appointing an MPA will be simplified in comparison to the one in the UK. It is proposed that a short form, possibly no longer than 2 A4 sides of paper, will be required to make the appointment of an LPA, and that form will be accompanied by a guidance booklet which will contain much of the information required to complete the form. Execution of the form will require the signature of the donor, the potential attorneys, and the signatures need to be witnessed. The persons who witness the donor's signature must confirm that in the witness's opinion the donor understands the purpose of the LPA and the authority that they are conferring, and has not been subject to undue pressure. So at the moment, it is not possible to make an LPA if you are a Jersey resident. However, an enduring power of attorney, the precursor to the LPA, or the LPA made in the UK by a UK resident, can be exercised in relation to assets in Jersey, provided it has been registered by the Judicial Greph. Regulations made under the law may make further provision for the purpose of recognising UK LPAs, and further work will be undertaken to ensure that LPA fidelity is made in Jersey is fully recognised in respect of the assets in the UK. It is important to note that a health and welfare LPA will not authorise the giving or refusing of consent to life-saving treatment unless the instrument contains expressed provision to that effect. So this is what we're talking about there, sir, is life-saving treatment, not ending somebody's life. Further, the donor may place conditions or restrictions to the exercise of the authority by an attorney and may at any time, whilst they still have capacity to do so, revoke the power. LPAs may be revoked as described in Article 17, which includes the situation where a person appointed by the LPA dies or loses capacity to act themselves. Article 18 preserves the validity of transactions already undertaken where LPA is revoked and the act's done in the belief that the authority had genuinely been conferred. Articles 19 and 20 of the law give the Royal Court jurisdiction to determine the validity of lasting powers of attorney, including any questions relating to whether the requirements for the creation of that LPA have been met and whether the power has or not been revoked or has otherwise come to an end. The Royal Court may direct that an LPA may not be registered or that one has been registered should be revoked if the Royal Court is satisfied that fraud or undue pressure was used to induce a person to make the LPA, or if the attorney has behaved or is behaving or is proposing to behave in a way that contravenes his authority or is not or would not be in the donor's best interests. The Royal Court also has the power to determine any questions as to the meaning or effect of an LPA and to give direction with respect to decisions which the attorneys or attorney, if there's only one, have authority to make, which the donor lacks capacity to make. So Part 3 of the law provides that a person who is 16 years of age may make a decision in advance to refuse treatment if they lose capacity. What they can't do, though, sir, is appoint somebody until they're 18 to make decisions on their behalf. That's what I hope I'm trying to get at. Yeah? So 16, I'm looking at Deputy Lewis because I know he asked the question. So at 16, they can make decisions about their care. What they can't do till they're 18 is appoint someone else to make decisions for them. Okay? The effect of this is known as a advanced decision to refuse treatment, an ADRT, and the effect should be the same as the decision made with a person to refuse capacity. Article 21 provides that such decisions do not need to be expressed in medical terms so long as they are clear. So Article 22 provides that where an ADRT concerns treatment that is necessary to sustain life, some formalities must be complied with in order that for the advanced decision to be applicable. So these formalities are that the decision must be in writing, signed and witnessed. In addition, there must be an express statement that the decision stands, for example, even if a person, we'll call this person P because I've used P a couple of times to demonstrate things as we work our way through the latter part of the law, sir. So the decision, in addition, there must be an express statement that the decision stands, for example, even if P, life is at risk. Life-sustaining treatment means treatment which, in the view of the person providing health care, is necessary to sustain life. Article 23 of the law describes the effect of an advanced decision, and Article 23(3) provides that medical professionals are not liable for the consequences of withholding or withdrawing treatment from P if they reasonably believe that the advanced decision has been made and it is valid and acceptable to that treatment. So can I ask the Assembly to approve Articles 11 to 23? That's parts 2 and 3 of the law.
Are the articles and the schedule seconded?
Yes, sir.
Does any member wish to speak on Articles 11 to 23 and the schedule? Deputy Kevin Lewis.
Thank you, sir. Apologies for labouring the point, sir, but it wasn't so much power of attorney I was inquiring. It was something that the Deputy of St John highlighted yesterday as whether somebody under 18, according to the schedule here, is interpreted as a child. And a child, I know 16-year-olds have the age of consent and they can vote, but they can't go into pubs, buy beers and go off to war. It's this definition of what is and what is not a child. On the bottom of the schedule on page 13, matter of an infant, 1995, and it says, we are in no doubt we should adopt the principles described in English law, blah, 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 reflecting the laws of Jersey, that an adult, a competent adult with full capacity has an absolute right to refuse consent to medical treatment or to take food and drink for any reason or for any reason at all, even when the decision may lead to his or her death. Is a 16-year-old competent to make that kind of decision? I know the Minister said they should be, but I wonder if we can have a definition in law, possibly from the Solicitor General, if that is the case. Thank you, sir.
Does any other member wish to speak on those articles? Deputy of St John.
Thank you, sir. I'd just like to understand in practice how the advanced decisions would work, in particularly whether it was in a medical setting or how those people would know. It's just the practical elements of that particular advanced decision. And in Article 22, it specifically says in paragraph 4, an advanced decision is not applicable to the treatment in question if, A, the treatment is not treatment specified in the advanced decision, but how does somebody know that at that point in time, and how is that considered going forward? Thank you, sir.
Does any other member wish to speak on this part of the law? If not, Minister?
Thanks, sir. I don't know if the Solicitor General can help me with the 16 versus 18, as we did have very, very long discussions about this, and settled for 16-year-olds being able to determine what treatment they wish to have, but not being able to appoint someone till they're 18 to make decisions on their behalf. But I don't know if the Solicitor General can explain it better than I can, sir.
I think he rises.
I will attempt to do so, sir. The general age of majority is 18 in Jersey, but it's open to specific legislation, such as this, to vary that position if this Assembly decides that's appropriate. And in this case, we're dealing with Part 3, and it's Article 21(1), and it specifically states that advanced decision means a decision made by a person aged 16 years or over. So this law is giving specific jurisdiction or ability for a 16-year-old to make a decision about their treatment in advance. So yes, so I confirm the Minister's previous answers. Just going back to a question that was raised whilst I'm on my feet by Deputy Martin about decisions to refuse treatment in advance. This would be the first legislation that I'm aware of in this jurisdiction that confirms that ability, but it is confirming something that already exists and has been recognised by courts here, by the Royal Court. So the Royal Court in the case of Attorney General and X, which concerned a situation where a prisoner in Lemoy was on hunger strike, and the court specifically confirmed in that case that the prison authorities and the medical authorities were not obliged to administer treatment to that prisoner where he'd become incapacitated through hunger strike. So the court already has, at least once, it has recognised an advanced decision to refuse treatment in this jurisdiction.
Thank you very much. Minister?
Thank you, sir. And picking up on the Deputy St John, we had discussions as to how would somebody know that someone had expressed a wish not to be treated or to be treated in advance. And whilst that's not set out in the law, sir, the intention is that GPs and the hospital will have that on record, and we've yet to bring in a system to do that, and they'll be worked up with the regulations. Deputy St John asked what happens if a situation in the advanced decision for treatment isn't covered in the person's advance decision. Is that right?
Sorry, so particularly in Article 22, paragraph 4, where it states an advance decision is not applicable to the treatment in question if, A, the treatment is not treatment specified in the advance decision. I'm just questioning in terms of there may not be those particular treatments around at the time you make that advance decision in future. What's the situation with regards to that?
I would have to be guided by the Solicitor General, but I think it's quite specific, sir. I think, and the Solicitor General will correct me if I'm wrong, that if the person hasn't covered that in their advance decision, then there is no advance decision for that particular aspect of treatment. Of course, the person has the right to change their advance decision at any time that they have capacity.
Solicitor General?
Yes, that's correct, sir. If it is not clearly specified in the advance decision notice, then it would not be covered. If there is an element of ambiguity around the language used, then there is a jurisdiction for the court to consider the language used and rule upon it, and that's in Article 23, 4 and 5. So it has got the ability to make declarations about the validity and the treatment that it encompasses. So.
Minister.
Thanks, sir. And I think that covers the questions that was asked. So I ask the Assembly if they vote on Articles 11 to 23. That's parts 2 and 3 of the law.
All those in favour of Articles 11 to 23 and the schedule, kindly show. Those against? The articles are adopted.
Thank you, sir.
Minister.
Part 4 now. It is the intention, sir, with this new law to encourage as many people as possible to make LPAs lasting power of attorneys. However, there may be situations in which a person loses capacity for which a decision for themselves, loses the capacity to make a decision for themselves and has not appointed an attorney to make a decision for them, whether that be about their care, whether it be about treatment or property and other affairs. So the present 69 mental health law makes provision as to how the affairs of such a person may be handled. It provides for a person subject to meeting certain tests to be received into guardianship for the purposes of making some decisions about welfare matters, or, under the current law, to have a curator appointed to manage the person's financial affairs. And as I've said before, sir, there are limitations in respect of the curatorship and the guardianship, which cause difficulties in practice. In the new mental health law, which we debated yesterday, it was proposed that guardianship should be retained for use principally in respect of those patients who have capacity but require some support to protect their welfare whilst they continue to live in the community. While some minor amendments and enhancements have been sought to these powers in those instructions, the powers of the guardian will remain limited to reflect their purpose. The current curatorship provisions in the 1969 law allows for a person to be appointed by the Royal Court, known as the curator, to manage the affairs of a person. However, these provisions have a number of limitations, as we've talked about over the last 2 days. In some respects, sir, as I've indicated, they are too restrictive. They are inflexible, and they do not allow curators to deal properly with the person's assets. For example, Article 43(17)(a) of the 69 law requires the curator to apply to the court whenever it appears necessary or expedient to arrange for or to authorise sale or exchange or charging of any other disposition or dealing with the property of the person. Such an application is then examined by 2 jurats who decide whether the action is necessary or expedient. So I would argue that this regime has been too cumbersome. That's the feedback that we got back from very many of the people that came to our consultations. They say it has been too restrictive, particularly when the curator, as I indicated earlier today, sir, was the person's spouse or civil partner. Further to the provisions at present, the Attorney General require the Attorney General to make application to the court for the appointment of a curator even when there are few or actually no substantial assets to manage. Also, there is currently insufficient control on fees, which my Assistant Minister was talking about before, that may be charged by curators, nor are there sufficient powers or resources devoted to the examination of accounts filed by curators. There have also been difficulties in persuading some lawyers to undertake curatorship, especially when the person has little in the way of assets. And it is unlikely that the curator will be able to recover fees for the work done as legal aid. So generally, the Viscount's Department currently provides a service as curator of last resort, but the resources for this work is very limited. And aside from the powers in the 69 law, it is important to recognise that the court also has non-statutory powers to make decisions on behalf of a person who lacks capacity. So it's a court at the moment making decisions on behalf of a person who lacks capacity for to make a decision for himself or herself. These powers form part of the inherent jurisdiction of the Royal Court, and whilst best interest decisions these powers form an inherent jurisdiction of the Royal Court, and whilst best interest decision making should really in general be a matter for doctors. Where the decision is of sufficient gravity, the Royal Court can intervene as a safeguard and grant a declaration as to the person's capacity or best interest. The new mental health law has sought to repeal, and that's important, repeal, not replace the law with respect to curatorship. We've left the curatorship in place in case this law is not yet in place when the new mental health law comes in. Starting again. In place of the system, the new law will codify and supplement the inherent jurisdiction of the Royal Court, giving it express powers to make decisions on behalf of a person who lacks capacity to make decisions for themselves. The Royal Court is also given the power to appoint a person referred to as a delegate to make certain decisions, where the Royal Court cannot make a one-off decision to resolve issues. The provision for the Royal Court or delegate to make decisions on a person's behalf would replace the provisions for curatorship and would provide an alternative to the receipt of a person into guardianship, particularly when the person does not have capacity to make decisions about welfare matters for himself or herself. So similar to the LPAs, the new law provides that delegates may be appointed to make decisions on either health, welfare, or the property affairs of a person, or both. The extent of the delegate's authority would be determined by the Royal Court, Article 24, and could be limited to particular decisions by reference to a particular period of time. Article 25 lists the persons who may apply to the court to exercise its powers. Article 26 sets out the procedures to be followed for application to the court in respect of a person who is undergoing treatment in an approved establishment or who are received into guardianship under that law. In such cases, applications may be made by the Attorney General. Article 27 makes specific provision to the kinds of decisions which may or may not be made by the court. Article 28 makes similar provision as to the powers which may or may not be exercised by the court or delegate appointed to deal with a person's property or affairs. So Article 29 enables a court to order reports as to a person's conditional circumstances for the purposes of the exercise of the court's powers under Part 4. Article 30 sets out the powers of the court in relation to making wills and requiring or authorising persons, whether appointed as delegates or not, to do so on behalf of the persons. Article 31 provides that the court may make vesting orders and may, in certain circumstances, revoke or vary settlements on trust or make orders or give directions to preserve beneficial interest. Article 32 confers powers on the court to order or direct expenditure for the maintenance or permanent benefit of a person's property. Article 33 is a regulation making power to enable further provision to be made as to the court's powers under Part 4. The appointment of a delegate by the Royal Court should not limit the jurisdiction of the Royal Court to consider any matter relating to the person who lacks capacity. The Royal Court will still be able to make declarations, decisions and orders affecting people who lack capacity. The Royal Court will need to be involved in complex or disputed cases, for example, when it is unclear whether someone lacks capacity or what is their best interest and what is in their best interest, and the decision is significant. The new law provides the Royal Court with the power to make a declaration or order, to give direction to make an appointment on such terms that it is clearly in that person P's best interest, even though no application before the court for an order, direction or appointment of those terms. So Article 34 deals with qualifications such as the requirement that an individual must be aged over 18 to be appointed as a delegate. Article 35 sets out general powers of delegates to do everything which appears necessary or expedient to be done in the interests of the person. Article 36 of the law further provides that delegates may do such things that are necessary or expedient to be done in P's interests, subject to conditions and restrictions placed by the authority of the delegate by the court. Article 24(3) of the law requires the Royal Court to consider what powers what powers is appropriate for the delegate to have. So Article 36 contains the powers for the states by regulations to make provision to confer appropriate regulatory powers on the public authority for the purpose of supervising and regulating attorneys and delegates. So could I ask the Assembly if they would vote on Articles 24 to 36, Part 4 of the law.
Are the articles seconded?
Yes, sir.
Does any member wish to speak on Articles 24 to 36? Senator Ferguson.
Yes. Yes, it's not altogether clear how the court is going to actually hold the delegate to account. You know, if there are any assets, particularly with the dementia case, which is something I do know something about, the individual for whom you are a delegate is particularly vulnerable. And I'm sorry to keep harping on about it, but will the Minister confirm that the discipline of submitting accounts annually will be included in the regulations, since I can't find anything here in the primary law? You know, submitting a set of accounts is a discipline that if the accounts don't appear, then it's obvious that there's something going on that might not be right, and you can actually take action. If you just leave it and you don't have accounts submitted, then there will possibly come a time, and, you know, all the people who are permitted to be delegates, you know, might be incompetent or might just be fraudulent. And by the time you find out that there's anything wrong, any assets have gone walkabout. So I really think we do need to have controls somewhere in the setup. As I say, I apologise for going on about this, sir, but it's something that, you know, I've been there and I've done all this, and I actually appreciated the rigour with which the judicial greffe actually said, accounts every year, please, because it did help, you know, preserve the controls.
Senator Orseth.
Thank you, sir. Senator Ferguson makes some important points, and I just make the observation en passant that the debate that we're having on this and the points that have been made and the ministers need to go through this is perhaps reflective of the fact that this is the kind of legislation that perhaps ought to have been at a committee stage and these questions resolved before it comes to this Assembly as a whole. I just make that as an observation because the Minister is right and Senator Ferguson is right to ask questions, but these are the issues of details that actually
scrutiny of legislation would have dealt with before rather than. But it's important it's got right. And I would say, in response, the Minister will respond, but in response to the points that Senator Ferguson makes, first of all, I think that we should take this opportunity of thanking all of those, because we're moving on from a court system of curatorships, which I have also personal experience of, not myself, but somebody very close to me. And the court has been extremely flexible and pragmatic in the way that they have handled what are effectively administrative matters, which shouldn't really happen in that way. But also, what is being made and the changes that are being made has to be correct, because it is completely accounts may be needed to be included in regulations, and that's fine, that's okay. But what we're doing and what the Minister is proposing is effectively a significant administrative easement and making and allowing decisions to be made for people that are incapable of looking after their own affairs. And as we look in an ageing society, there's going to be more and more, and this is the point has been made about the judicial grefт. The judicial grefт with people with no assets have acted as the curatorship, working with the flexible court system, and the burden this has put on our judicial greft department has been absolutely enormous. And so it's just, the old system just doesn't work. It doesn't work, it's too cumbersome. It might have worked in a world where people died at the age of, average age life expectancy was 55, and there weren't many of these things, and all the rest of it, but we're not living in that world anymore. And we also understand what mental incapacity means, and the fact that at the centre of this should be the individual, rather than a cumbersome arrangement which simply didn't meet the desired and expected wishes of the person who is actually not able to take their decisions for themselves. Sometimes they understand, and sometimes they don't. So I say that we shouldn't almost be having this debate, because it should have been dealt with at a committee stage. But secondly, there's no reason why, and I'm sure Senator Ferguson isn't saying that she's not going to support this part of the law, because it is a massive improvement. It's good for the people. It's good for the people who are charged with the difficult responsibility of looking at people with issues, and also, and it can be made to work and work properly and more efficiently, and it will ease the huge burden that the judicial greft has had over so many years. I support it.
Deputy Tadier.
It's just on a procedural matter. We have a minister who stands up suggesting that this should have been looked at a committee stage, and that scrutiny should pick up on this kind of thing. It'd be good to know whether or not actually the ministers themselves asked for this to be put to scrutiny in advance, so that they can actually look through the areas. Of course, they're a busy panel anyway, but I think it's too easy for a minister to stand up and say, oh, you know, a new senator shouldn't be coming into the Assembly and bringing these issues now. This should have been dealt with before. And of course, the issue of legislative scrutiny is a critical one, and I think that's partly why the Minister is taking these article by article, because it's important that these things are debated, and no doubt he may have taken counsel from other senior ministers to make sure that these things do get aired. So it's quite right the place to do it. And of course, the general issue of when legislative scrutiny happens is a good one. But the point remains that Senator Ferguson's questions are quite legitimate. If she's saying that there isn't sufficient probity in what's currently being presented to the Assembly, and that actually what's quite reasonable, that accounts should be presented, are not in the current law, can the Minister actually give an assurance that when it comes back in the regulations that these provisions will be there? Because I think it's unfortunate for members to feel that they're in the position of voting for something blind and then finding out maybe a few months or years down the line that actually the relevant safeguards that they would have wished to be put in law have not actually appeared in the regulations, and therefore regret the decision that they've made today. So I think that's a reasonable request, irrespective of at what stage scrutiny is or could have been carried out.
If no other member wishes to speak on these articles, I call the Minister. So
picking up on Deputy Tadier's comments first, we did discuss the matter with the scrutiny panel. They are a very busy panel at the moment. They're, amongst other things, they're scrutinising the work around the need for a new hospital and the hospital site. They did cast an eye over it and decided that they would prefer to, I think I don't want to put words in the mouth of the chairman, that they would prefer to scrutinise the regulations. He's nodding, so there was some discussion with the panel about that. Picking up on your second point around whether accounts should be present, and Senator Ferguson's point as well. Senator Ferguson has been consistent in her comments about that. To be fair, I can remember standing at the town hall and having that discussion as well. So I think there's some confusion about the role of the person with the power of attorney and the delegate. The delegate is somebody appointed by the Royal Court, and because nobody else has been, because an attorney hadn't been appointed, and the court's free to put any conditions on that they wish. When it comes to the attorneys, then, so what I did say is we're trying to make a simpler but fair, nevertheless it has to be responsible system. And I did say that I would, when we're looking at regulation, look at whether it would be appropriate to ask people to keep accounts and them to be available for inspection. Now, it may be that people with assets below a certain level wouldn't need to. It may be that the spouse wouldn't need to, would carry on running the household in the normal way. These are things that we will, I guarantee, that we will look at under regulation. Haven't dismissed it, but I am trying to get a user-friendly system, but also understand the need to be sensitive to ensure that people are not defrauded of their assets. So with that, sir, I call upon the Assembly to approve 24 to 36.
We have the appel, please.
The appell's been called for on Articles 24 to 36. I ask members to resume their seats. I ask the greffier to open the voting. All members have had the opportunity to vote. I ask the greffier to close the voting. The articles have been adopted. 32 votes per, no votes contra. Minister.
Thank you, sir. And we're well on the way now. And I know this is tedious for members, but these two laws that we've been doing over the last couple of days, I believe, will be the most important laws that this Assembly will debate. And I think it is right that we, rather than just en bloc, which we sometimes do with some things, that we do examine, challenge, and ask questions about the different articles. So I don't apologise for it, but I do acknowledge that I am taking a long time. But also I'm in the seat of former Senator Lamuckle that used to like to do that as well. So part 5, sir, we're looking at capacity and liberty. Part 5, so in some cases where a vulnerable person cannot consent to the arrangements for their care and treatment, it is important that there are appropriate powers for those caring for them to be able to restrict their liberty or movement in order to prevent them from coming to harm. Article 37 is the interpretation and provides the provision for those purposes of Part 5. So in order to protect the vulnerable person's human rights, it is important that significant restrictions are only imposed pursuant to a legal procedure that protects against arbitrary interference with their liberty and private life, that affords them the opportunity to challenge the imposition of these restrictions in an independent and impartial tribunal. So Article 38 provides that basic safeguard, which is that a sufficient restriction which might amount to deprivation of liberty may only be imposed only and only if, in respect of a person lacking capacity, an urgent or standard authorisation of such a deprivation has been granted by the Minister, or an order of the court has been made granting a similar authorisation, or the restriction is necessary to enable the administration of life-sustaining treatment. Article 39 defines the measures which amount to significant restrictions on liberty if applied on a regular basis. Such measures include not permitting a person to leave a relevant place, controlling the person's access within the place, controlling the person's actions, and subjecting them to continuous supervision. So whilst some vulnerable persons will most appropriately be detained for assessment and treatment under the powers provided in the new mental health law, for other persons, including most of those persons with a learning disability or degenerative condition like dementia, authorised detention in an approved establishment under mental health legislation will neither be the most appropriate nor the least restrictive in their approach to their care. So in England, special provision was made in the Mental Capacity Act 2005 to insert a provision for the deprivation of liberty safeguards, referred to as DOLS. DOLS provide legal protection for those people who lose capacity to consent for the arrangement for their care or treatment and who are or may become deprived of their liberty by nature of the arrangements that are made in their best interest. Their purpose is to ensure that there is a professional assessment of whether the person concerned lacks the capacity to make his or her own decision about whether to be accommodated in hospital or in a care home for treatment, and whether it is necessary in her or his best interest to be deprived of their liberty. However, while DOLS provide a process for protecting patients' rights, they have been the subject of a great deal of criticism in the UK. In particular, there has been criticism of the complexity of the regime and the limitations on the application, since it does not apply to placements outside of hospitals and care homes. There has also been confusion about how the regime should be applied in combination with the detention powers of the mental health legislation. Therefore, Sir, Part 5 of the law contains appropriate alternative statutory safeguards to those found in the mental health law to authorise significant restrictions on the liberty of a person who lacks capacity in any environment where they may be provided any environment where they may be provided with health and social care. Part 5 makes arrangements so that such restrictions as are authorised are kept under review and may be challenged. By doing so, Jersey can ensure that its obligations under the Human Rights Jersey law and Article 5 of the European Convention of Human Rights are met. So the content of Part 5 reflects a careful balance in line with the feedback from the consultation exercises between a robust procedural safeguarding and ensuring that the system is straightforward and easy to apply in practice. The aim is to ensure that the assessments under Part 5 can be conducted by the same persons who are conducting assessments for social work purposes generally under the long-term care Jersey law. In particular, sir, the persons carrying out those assessments will be trained to assess capacity and the best interests so that they will be well equipped to carry out the assessments required under Part 5. So under the Regulation of Care Jersey Law 2014, the provider and manager of every establishment providing health and social care will need to be registered by the new Independent Health and Social Care Commission established under that law. Under Part 5, providers of health and social care services will be required to request an assessment from a registered care professional, who may be a social worker, nurse or doctor, if they think that they will need to impose significant restrictions on a person's liberty in order to care for them in a way that protects them from harm. So the registered care professional will assess whether the person has capacity to consent to the proposals for their treatment, and if not, whether the arrangements would involve significant restriction on liberty. Whether those arrangements would involve a significant restriction on liberty, and that it is necessary and that it is in the best interests of the patient. The shift in terminology away from referring to deprivation of liberty under DOLS towards referring to significant restrictions on liberty is an important one. This move is both inspired by the difficulties in explaining to practitioners what deprivation of liberty is, and also the recent reports that we have read from the Scottish and the UK law commissions. Both commissions recommended that a process should be put in place to authorise any significant restrictions in liberty, because unlike the deprivation of liberty, it is a concept that can be defined for that jurisdiction by reference to European Court of Human Rights case law. Whilst the concept of significant restriction would not expressly match the concept of deprivation of liberty, it has been defined in Article 39 of the law in a way that should be clear to service users and professionals and would capture the types of restrictions that could be said to give rise to a deprivation of liberty or to amount to an interference with the right to private and family life. Article 40 imposes a duty on the minister to designate independent assessors who must be registered medical practitioners or persons otherwise in registrable occupations under the Healthcare Registration Jersey law, and they carry out assessments under Part 5 of this law. It confers the power to make provision by order to enable fees to be charged in respect of such assessments. The Minister must also maintain a register of persons appointed as assessors. So Article 41, brackets 1, the Minister must not authorise a significant deprivation of liberty unless the authorisation is urgent, as defined by Article 42, or an assessment has been carried out in accordance with Articles 43 to 46, which have concluded that significant deprivation of liberty is justified. Under Article 41, brackets 2, the Minister must appoint an assessor to carry out initial assessments upon receipt of such a request, or where the Minister otherwise becomes aware of conditions in Article 43, brackets 2, are fulfilled. Article 43 provides that where a person lacks capacity or is or will be subject to a significant deprivation of liberty in a relevant place, the manager must notify the Minister of those matters and must request an assessment of the person. The assessment conducted by the registered professional under Part 5 must be conducted in accordance with the Articles 44 and 45, and it must be supported by appropriate medical opinion. This may arise from a person's medical records or from an interview with the medical practitioner responsible for the person's care and treatment. The assessment may also take account of interviews with the representations from such other persons that are listed in Article 44 and who may, in the assessor's view, be appropriate. These include the person's guardian, its nearest relative, delegate appointed under Part 4. So the assessment must be such as to enable the assessor to form a view whether the person lacks capacity to consent to the arrangements for his or her care, and whether it is necessary to impose significant restrictions as a component of that care or treatment, and if so, whether it is in the person's best interest for such a restriction to be imposed. So at the conclusion of the assessment, the assessor must prepare a written report setting out their conclusions on the following questions. Back to Mr. P or Mrs. P or Miss P. Does P lack capacity with reference to the question whether or not he or she consents to the arrangement for his or her care? With regard to P's care, is it necessary to impose any significant restrictions on P's liberty in the interests of P's health or safety? And having regard to the general principles and provisions of law, is it in P's best interest to be provided with care in circumstances where a significant restriction on his or her liberty will be applied? The registered assessor's report should set out the recommendations as to the nature of any significant restrictions on P's liberty. That registered assessor and why that registered assessor thinks it's necessary to impose. Article 45 requires the assessment to be provided to the Minister within 21 days of the appointment of the assessor, and to include such matters that are specified in the article. Article 45 also requires a copy of the report to be given to the manager. All assessments must be submitted to the Minister, who will be responsible for ensuring that the application is properly made, and that if and that, if recommended, confirms that it imposes the imposition of significant restrictions are authorised. So in practice, this role might be performed by the medical health administrator, whose role is provided for under the new law that we debated yesterday. An authorisation would allow a care provider to impose one or more significant restrictions on someone's liberty. So if the report that the assessor has made considers that the imposition of significant restriction on liberty is justified, then, and the effect of Articles 46 and 48 is that the Minister may authorise significant restrictions for a period of no more than 12 months, referred to in the law as a standard authorisation. So in general, this would be for a maximum of 12 months, with an option to renew after a further 12 months. Sorry, sir. This pattern of review has the advantage that it may coincide with the pattern of review for care plans for the long-term care arrangements, although it would be different to the pattern under the new mental health law. And that is justified on the basis that many people who would be subject to Part 5 authorisations will have permanent learning difficulties or degenerative illnesses, where there is a much lower likelihood of a recovery or improvement or change in the person's circumstances in a short period of time. Once authorisation is in effect, the manager and staff of the care home have the authority to impose the restrictions on P's liberty. They should suffer no liability for acts done for the purpose of maintaining significant restrictions that the person would not have incurred if P had capacity to consent to the act and had consented to it. So there is no exclusion or of civil liberty for loss or damages or criminal liability resulting from that. So, however, the manager who has given authority to impose significant restrictions on P's liberty must keep the necessity to maintain any restrictions under review at all times. If at any time the manager considers that it is no longer appropriate to maintain the restrictions, they should cease to do so. The system for challenging the imposition of authorisations under Part 5 of the law will be similar to those of challenging the compulsory detention under the mental health law, i.e. the Mental Health Review Tribunal should be the forum in which the challenge could be heard. Because issues involved in such cases have a close affinity with the challenges that may be brought concerning the detention under the mental health law, there will need to be specific and special rules of procedure for the cases under the law compared with the cases under the mental health law. This is something that will be considered further as part of the implementation process of the law, similar to Articles 12 1969, sir, within the mental health law, where a person has not already been admitted to a place where authorisation has been given to impose significant restriction on the person's liberty, then the authorisation, whatever type it may be, should be treated as providing sufficient authority for the registered assessor or manager, or any other person, or authorised by persons to take that person and convey him or her to a place of significant restriction of their liberty. This may be lawfully imposed at any time within 72 hours of the grant of the authorisation. So the Minister may, by order, prescribe the forms that shall be used by all of those carrying out assessments and authorisations. The Minister may give urgent authorisation to impose significant restrictions on liberty where it is necessarily so in the interests of P's health and safety, allowing the managers to propose significant restrictions on P's liberty. The urgent authorisation may last until the assessment is completed and an authorisation is granted for no longer than 28 days in total. The Royal Court will have a similar power to authorise the imposition of significant restrictions on P's liberty. So, for example, where the Royal Court determines that P lacks capacity to make a decision about where and how their health and social care is provided, and decides that the person should be cared for in a particular facility, and authorises the imposition of significant restrictions on that liberty, the Royal Court may only do so, may only make an order authorising the imposition of serious restrictions on P's liberty where it has received evidence from a medical practitioner and is satisfied that P lacks capacity, and it is necessary, and this is really important, necessary in P's best interest to impose that significant restriction on his or her liberty. Once in place, authority is provided by the Royal Court to impose a significant restriction on liberty. Once in place, authority provided by the Royal Court to impose a significant restriction on liberty should be treated for the most purposes in the same way as authority to provide a standard authorisation. So Article 46 provides that if an assessment is negative, no further assessment may be carried out and no standard authorisation may be granted to impose deprivation of liberty, except where there is a material change justifying a fresh application for assessment, or an assessment has been carried out and was mistaken in the material respect. Article 47. Article 47 requires the Minister to keep a record of all assessments carried out and all authorisations given under Part 5. Article 48 obliges the Minister to give notice in the form to be specified by Code of Practice of the authorisation to the manager of the relevant place and to the assessor. Article 48 also makes provision as to the powers of the Minister to authorise restrictions that are recommended by assessors. Article 49 permits reports of assessments which appear to the Minister to be incorrect or defective, or to be rectified by the Minister or with the Minister's consent by the assessor. Article 49 also imposes a duty on the Minister to give notice if a recommendation in the report is insufficient or found if a recommendation in the report is insufficient to found a significant deprivation of liberty, and that the recommendation is therefore disregarded. Article 50, the person affected by the restriction must be notified of it, and all the rights of advocacy, support and review available under the law. That the information must be given to the person affected, both in writing and orally, and must also be given to anyone acting on behalf of the person, as listed in Article 44. If the person has no such representative at the time, Article 51 provides that the Minister should appoint an independent capacity advocate, in accordance with Part 6, to represent the person in a significant deprivation of liberty situation. A standard authorisation may not be renewed except in accordance with Article 52. So, the Minister may, as soon as practical, appoint an assessor to carry out a renewal assessment, and if the report of that assessment is affirmative, the Minister may renew a standard authorisation or request a further medical assessment. Further mechanisms for review of authorisations are Articles 53 and 55. Article 53 imposes a duty on the manager concerned to keep under review the necessity for every significant restriction authorised by a standard authorisation. Article 54 preserves the continuity of authorisation where there is a change in the identity of the manager or relevant place. Article 55 provides for the review of authorisations by the tribunal on the application of the person concerned or his representative, the Minister or the Attorney General. Only one such application may be made during a continuation of a standard authorisation. Article 53 confers an order-making power to ensure that the provision to be made as to applications to and proceedings before the tribunal and the tribunal's powers to dispose of applications. Articles 55 go on to set out the tribunal's general duties. Article 56 enables the Minister to monitor the application and use of authorisations and the operation of significant deprivation of liberty. Article 57 gives the Royal Court the power to make an order authorising the imposition of significant restrictions on liberty. Where the person lacks capacity or to give consent to the arrangements for his or her care or treatment, and it is necessary And again, back to the same old thing, sir, necessary, but in the interests of the person's health and safety, or in their best interest. To be valid, the order must comply with Article 57. 59, Article 59 makes it lawful for one person to temporarily impose significant restriction on another's liberty where the restriction is essential for administering life-saving treatment. Article 60 provides an authorisation, including an order of the court under Part 5. Article 60 provides that an authorisation, including the order of the court, under Part 5 is sufficient authority for a person to whom it relates to be taken and conveyed to a relevant place and admitted and detained there for a specified period in the authorisation. So I could ask the Assembly to approve Articles 37 to 60.
Are the articles seconded?
Yes, sir.
Senator Ferguson.
Thank you, sir. I'm making up for lost time. Basically, I don't understand quite where the 12-month figure comes from. For the, I perhaps have misunderstood it, but it seems that there's a report and an assessment, and that then puts somebody into effectively a safe place for 12 months, which seems somewhat draconian, and there is only one allowable review of the authorization by a tribunal. Now, I understand it's slightly different in the UK, where there's an automatic review, I think, after 6 weeks, isn't there? So perhaps the Minister would like to put me right on that one, sir.
Deputy of St John.
Thank you, sir. Well, I hope it's a simple question. Article 59, which talks about the temporary restriction of liberty for purpose of life-sustaining treatment. And just trying to understand how that fits with regards to the advanced decision, the part, I think it's part 2 or part 3 of the law which we've agreed. I just like some understanding of the practicalities of that, especially when it's a situation that you need to make that decision at the last minute, or they may have placed within their advanced decision certain treatment that they need at that particular time. So just like to understand fully how that would work.
Deputy of Greville.
This goes back to my earlier point, and I have to say I wasn't altogether comforted by what the Minister said, in that, well, that's the law of the land, end of. I think the law of the land needs to be looked at when we're bringing this kind of legislation in, because there seems to be some sort of inconsistency and conflicts in this legislation. When we speak, going back to my earlier point of making a living will, not to have one's life prolonged if a person is incapacitated in some way and has no life and no chance of having their life improved, that they've got no prospect of their life getting better. But there seems to be some conflicts between the person's wishes, the deprivation of liberty, and doing what that person considers to be in their own best interest, because they made a living will before they lost capacity to make their own decisions and do things about it. I mean, I understand, and I'm obviously going to vote for this because it's a vast improvement in principle, but I think when we go through the regulations, I will want some detail, and I will want all these things about deprivation of liberty and a person's best interests considered in the full, to the full. And it might just be that we need to sort of bring forward additional legislation or propositions to have a look at the law of the land. Thank you, sir.
Does any other member wish to speak on these articles? If not, I call the Minister.
Thanks, sir. And dealing with Deputy of Grouville first, I may need the help of the Solicitor General on this one, sir, but for me it seems quite clear that if someone wishes not, and have made it clear by doing the appropriate paperwork and all the rest of it, that they don't wish to have life-sustaining treatment, that's one thing, sir. But they cannot ask somebody to actually deprive them of their life. That would be manslaughter or murder. I don't know, I'm not a lawyer. So to withhold treatment because a person has asked for that to be withheld when they had capacity is one thing, but to actually advance their death would be illegal. I don't know if the Solicitor General has a comment to make on that.
Solicitor General?
Yes, I agree with that distinction. I note that in Article 57(6) of the draft law, that where a person has made an advance notification concerning their treatment and not to receive treatment, and they've complied with the formalities and the terms of it are clear, that not even a court has the ability under this law to make an order that they be treated contrary to the terms of that notification. So it is a significant protection for the person's wishes that provided that they have complied with the requirements for that notification. I hope that assists the Minister.
I don't know if that helps a Deputy Grouville.
Well, my point is, it is illegal now, but I would like it considered, so maybe we can take these factors into account, and so other possibilities make it not illegal.
Minister.
So I think we'll have to agree to disagree on that, although I will have a chat with the Deputy afterwards to see if I've misunderstood, because at the moment we're doing the principles and the articles, and of course the regulations, as the Deputy said when she was speaking earlier, come later. So I will have a chat with her later to make sure I haven't misunderstood what it is she's trying to tell me. So Senator Ferguson, again, I'm not a lawyer, raised the 12-month one review. The 12-month standard is normally used where someone has a condition not likely to be improved, as I understand it, but there is still a review within that. And the Deputy of St John asked me, was the fact that they could give, that, for example, like accident emergency could give treatment against, because the person didn't have capacity, was that not against their perhaps, I'm trying to think of it now, the living will? No, because if the living will is in place, then treatment won't be given. But if life-saving treatment is needed and there is no indication that that person doesn't want to have that, then, and the person has no capacity, maybe that they're unconscious, then the medical practitioner has to make a decision in the best interest of the patient. Does that make sense? I'm getting a strange look, sir.
I'm just trying to think in my head. In one note, you're saying that for the life-sustaining treatment, as long as it's not listed in their advance decision, then that can be given because of Article 59. But if it's in the best interests and it is in the advance decision, sorry, I just
No, I'm not saying that. What I'm saying, sir, if there is an advance decision that they don't want to have that life-saving treatment, then their decision is respected. If there isn't an advance decision, but the person does not have capacity, then life-sustaining treatment can be given without putting the general, the doctors and the surgeons at risk of prosecution. Does that make sense? Okay, thank you. On that basis, I call upon the Assembly to vote on Articles 37 to 60.
Can I have clarification, sir? I did ask where the figure of 12 months came from.
Minister.
So I can't say exactly where the figure of 12 months came from, but it was, and I did mention that it was recognised that those are normally used where somebody has a condition not likely to be to improve, sir. But other than that, I'll have to speak to the senator separately.
All those in favour? Oh, Solicitor General.
Sorry, if it assists Senator Ferguson, it's the standard authorisation specifies that it's for a period of no longer than 12 months. So it's up to 12 months. It doesn't have to be 12 months. So it's and if presumably if the minister or medical practitioner is of the view that the period of restraint it can be dealt with in less than 12 months, then they would say a lesser period. And in fact, there would be, I think, an obligation on them to do so under this law.
Minister, have you concluded your?
Yes, thank you, sir. So could we have Articles 37 to 60, please?
All those in favour of Articles, the appeal has been called for on Articles 37 to 60. I ask members to resume their seats. I ask the greffier to open the voting. I think all members have had the opportunity to cast their votes, so I ask the greffier to close the voting, and the articles have been adopted. 35 votes per, no votes contra. Minister.
Thank you, sir. We're close to the end, sir, but I'm not going to apologise. This is really, really important. Part 6, sir, is independent capacity advocates. This part of the law makes provision so that, in particular, where important health and welfare decisions need to be made by or on behalf of a person who may lack capacity, that person should have access to an independent capacity advocate to be referred to as an ICA. And this is covered in Article 61, sir. Article 62 enables the states by regulation to require the minister to make arrangement for the appointment of such independent capacity advocates. Article 62, under Article 62, the minister must have regard to the principle that a person must be represented by another who is independent of that any person responsible for the decision in question. Article 63 sets out the basic functions of an ICA, which includes supporting the person to participate as fully as possible in any decision concerning him or her, obtaining and evaluating information in relation to representing and supporting a person or that person's best interests, obtaining further medical opinion and ascertaining alternative courses of an action, if any. That's covered under Article 63, sir. Regulations may also make provision as to the circumstances when an ICA may challenge or assist a person in challenging decisions affecting him or his or her best interest under this law. The ICA will be somebody who is independent with a knowledge of law, but not necessarily a lawyer. The ICA will be appointed to support a person who lacks capacity and may be particularly important where a person has no family or friends who would normally be able to represent their wishes and their feelings. The Health and Social Services Department anticipates that this role will continue to be funded by the department, but provided by a voluntary or community organisation. In particular, independent capacity advocates are to be involved in decisions as to serious medical treatment and arrangements for or changes to a person's accommodation in a relevant place, where either type of decision is under consideration by the minister or any other person with the power to make such a decision. So Articles 64 and 65 respectively provide that an ICA must be instructed to represent the person concerned and his or her best interest before the treatment is provided or the decision is taken, except in cases of urgency or serious medical treatment. And this is defined in Article 64. So, Article 64 proposes that treatment which would be likely to involve serious consequences for the person receiving it, or which would entail a fine balance between the risks and benefits of treatment for that person. The the ICA will be able to make representations about the person's wishes, their feelings and their beliefs and values, at the same time as bringing to the attention of the decision maker all the factors that are relevant to the decision. Detailed provision about the role of the ICA may be made by the States Assembly by regulations, including with regard to the circumstances where they may be appointed and the roles that they may perform. So Articles 51, 64 and 65 of the law make provision about the circumstances where the Minister might appoint an ICA to support a person in relation to decisions about the imposition of significant restrictions on the person's liberty. So I call upon the Assembly to approve Articles 61 to 65, and that's Part 6 of the law.
The article seconded.
Yes, sir.
Does any member wish to speak on Articles 61 to 65? If not, all those in favour of Articles 61 to 65 kindly show. Those against, the articles are adopted. Minister?
So, and finally, Part 7, miscellaneous and general provisions. Part 7 contains general and miscellaneous provisions, two of which create additional and general safeguards for persons lacking capacity. Article 66 enables the states to make regulations governing the extent to which and the circumstances in which intrusive research involving persons lacking capacity to consent to such research may be lawfully undertaken. And Article 67 creates an offence of wilful neglect, punishable by imprisonment of up to 5 years and an unlimited fine, by a person who has the care of another person, or is appointed under a lasting power of attorney, or as a delegate on behalf of another person. So there have been a number of cases in the UK, and also in Jersey for that respect, where neglect or abuse of a vulnerable person has caused them harm. So a care worker who mistreats or abuses a person that they are caring for might potentially also be prosecuted for other offences against persons such as assault. However, it may not always be that straightforward to prosecute such offences, especially when the person is not capable of consenting to the manner of their treatment. So the regulation of Care Jersey Law 2014 will enable the states to create a regulatory framework for health and social care that places the responsibility for quality of care and criminal liability on the managers and the providers of regulated health and social care activities. Criminal liability may arise from their failure to comply with the conditions of registration or from failure to comply with other requirements by virtue of Article 13, 14 and 1 and 6 of that law. However, it is only the registered provider, i.e. the owner and the manager, who are responsible for the institutional failings of this nature. They are the ones, therefore, that would be liable for prosecution in that case. The law does not contain new offences for care workers themselves. They would continue to be prosecuted under the existing general criminal law and potentially under the 69 law where that applies. So with this in mind, Article 67 law creates a new freestanding offence to cover willful neglect and abuse that applies to the treatment of people in care homes or provided within domiciliary care or supported living arrangements. An offence of this nature is provided in Section 44 of the 2005 Act. However, as the UK government noted, there are potential shortcomings in respect to Section 44, which is that it only applies to a person who has the care of a person who lacks capacity or other persons with a specific responsibility for the person who lacks capacity. This means that two vulnerable service users, one of whom has capacity, one of whom doesn't, who may experience the same ill treatment or willful neglect, may not be equal victims in respect to those acts. So rather than creating a parallel offence to that, in Section 44 of the 2005 Act, the Department proposes to, the Health and Social Services Department proposes to create an offence that would be equally applicable to service users being cared for by regulated health and social care services, which in the short term will cover all regulated care homes and domiciliary care businesses, and in the long term will also cover the primary care services and the hospital. So the offence should apply to those who care for persons with mental capacity or without mental capacity. It should also apply to persons who have specified responsibility in relation to a person who lacks capacity. For the purposes of this offence, a person should be treated as having the care of P if they are responsible in giving health or social care to P, that's my Mr. and Mrs. P again, as part of the activity that is not a regulated activity for the purposes of the regulation of care, Jersey law. So I want to be absolutely clear here. For the avoidance of any doubt, it is not intended to capture anyone within the scope of this offence who is employed by a business providing regulatory health care and social care to P. It is not intended that the new offence should capture family members or neighbours who, whilst might also neglect or ill-treat P, would not be providing regulatory services unless they do so for a commercial consideration. To do otherwise might dissuade people from volunteering, from being that good neighbour and popping in to care for others. The application of the new offence should then expand and contract with changes to the extent of regulated activities over time. Article 67 of the law provides that a person guilty of an offence under this section is liable to a term of not exceeding 5 years in prison, a fine, or both. Article 68, the Minister must issue codes of practice relating to the exercise of functions under the law by carers and donees and those of lasting powers of attorney, delegates and assessors. Failure to comply with the codes of practice is admissible as evidence where relevant to a question arising in criminal or civil proceedings, though such a failing does not itself amount to a liability. So Articles 69 and 70 would confer on the states and on the Minister respectively general powers to make regulations and orders. The power to make orders include the power to provide the amount of fees and charges under the law. Article 71 would extend the power to make the rules of court under the Royal Court Jersey law to include the powers to make rules regulating the practice or procedures before the court. Article 72 would provide for the customary law concerning curatorship to cease to have effect at the appropriate time. And Article 73 would provide the citation of this law. So I call upon the Assembly to approve the last article, 66 to 73.
Are the articles seconded?
Yes, sir.
Does any member wish to speak on articles 66 to 73? Deputy Rondell.
Thank you, sir. Just under Article 67, offence of willful neglect, could the Minister please explain where under 3, a person guilty of an offence under this article shall be liable to imprisonment for a term of 5 years and a fine? Where did the figure of 5 years come from? Because am I right in thinking this could lead to somebody's death?
So the offence of one of... beg your pardon.
Other members may wish to speak on the articles. If not, Minister.
Thank you, sir. And I may need the guidance of the Solicitor General, but the offence is one of willful neglect, sir, or rather than causing the death of somebody. And as I understand it, it reflects the UK law in terms of the 5-year punishment. But I can't go further than that. I don't know if the Solicitor General can help me, sir.
Solicitor General?
So the offence does reflect the maximum sentence in the UK law, and if it had resulted in someone's death, then I think prosecution for an alternative offence would be considered rather than under this one.
Minister, do you wish to?
So I can't add anything to that. That was my understanding, although put much more articulately by the Solicitor General, sir. So on that basis, I ask members if they would approve Articles 66 to 73.
Those in favour of Articles 66 to 73, kindly show. Those against, the articles are adopted. We'll come to third reading. Minister.
Thank you, sir. We're nearly there. So the need for capacity legislation in Jersey is beyond doubt. England introduced their Act in 2005, while Scotland introduced their Adults in Incapacity Scotland Act in 2000. Importantly, though, we have been able to learn from the implementation and practical problems that these two pieces of legislation experience. We recognise the value of the principles of capacity tests and best interest decisions within the English law, and that's why they've been included within our legislation. However, we also saw confusion surrounding the deprivation of liberty safeguards, and subsequent Supreme Court rulings ensured that our legislation has learnt from and improved on other jurisdictions' legislation. So we are the first, if we accept this today, we are the first jurisdiction to recognise the importance of self-determination within the capacity law. This law will give the citizens of Jersey the power to make decisions for themselves for a time when they may not have capacity to do so in the future. It provides a legal framework to protect the most vulnerable of people in our society. It leaves us in no doubt that whatever we do for people who lack capacity to choose for themselves, whatever we do must be done in their best interests. The consultation, sir, has been comprehensive. I'd like to personally thank the voluntary organisations who have contributed so much time and effort into the process, particularly Mind Jersey, and I'm really grateful for the work that Mind Jersey put in. MenCap Self-Advocacy Project, Age Concern, and Citizens Advice Bureau, sir. I would also like to express my thanks to the law officers, the law draftsmen, officers from the Chief Minister's Department, officers from my own department, who have in completing this substantial piece of legislation in just over 2 years is noteworthy, but we have ensured that it has been completed in tandem with the mental health law and demonstrates the commitment and the drive from this Assembly, but also all the staff and people involved, all the different agencies, to ensure people with mental health problems and challenges are treated with the respect and dignity that they deserve. And with that, sir, I ask the Assembly to approve this legislation. I ask for the appel.
Well, does any other member wish to speak on third reading? Senator Fry?
So I just wanted to say that as an observation, there'd been one or two, albeit mild, good-natured grumbles about the length of the time it's taken to debate the last two propositions. But I think so with sometimes the amount of trivia we do get involved in, it's really important that we take the time on such important debates. I have been following both pieces, article by article, as ably led through by the Health Minister, and I've certainly come out of this debate with a much better understanding as I came into it with, because of that, because of the time taken to go through it. I think the questions by members have been excellent and very ably handled by the Health Minister. And I'm saying this, sir, because I think if we all spent more time on serious and important debates like this, and less time trying to tear each other to pieces, this Assembly might just be a much more productive place.
If nobody else wishes to speak, Minister, do you wish to move straight to the...
Thanks. I'd just like to thank Senator Farnham for what he said. So I spent 2 hours this morning. Sorry. I'd like to thank Senator Farnham for what he said. So I spent 2 hours this morning seeing if I could substantially cut out bits of this. But when you bits of what we've covered under the different articles, when you do that, then actually the members would not get the full flavour for what we were trying to achieve, and it threw everything out of context. So I'm really grateful to members for putting up with me for this length of time. But this, I will say it again, sir, these two laws, yesterday and today, I believe are probably the most important bits of legislation, certainly for the people of Jersey, that this Assembly will pass. So with that, sir, I ask for the appel.
appel has been called for on the third reading of the draft law. I ask members to resume their seats. I ask the greffier to open the voting. I think all members have had the opportunity to cast their votes. I ask the greffier to close the voting. And the draft law is adopted in third reading. 46 votes per, no votes contrary. So we move on to the next proposition, which is Controller and Auditor General Board of Governance appointment of members. Ask the greffier to read the proposition.
The States are asked to decide whether they are of opinion, in accordance with Article 3 of the Controller and Auditor General Board of Governance Jersey Order 2015, to appoint Mr. Peter Price as Chairman and Professor Russell Griggs, OBE, as a member of the Board of Governance of the Office of the Controller and Auditor General, both for a period of 4 years with immediate effect.
Chief Minister.
Thank you, sir. So this is a proposition to appoint Mr. Price and Professor Griggs as the first appointees to the Controller and Auditor General Board of Governance. There is a full report and CVs there, so I think these people are two eminent people to start this board, and I'm sure that the Controller and Auditor General herself is going to find it extremely worthwhile, supportive, and enhance the role that she plays in delivering good value across government. And I hope that she will find these two individuals to be eminent in that role, and I ask members to support their appointments. Sir.
Proposition seconded. Does any member wish to speak? All those in favour of adopting the proposition? Yes, Deputy St John.
Thank you, sir. I just want to ask the Chief Minister, looking at the members of the panel that consisted for interview of these individuals, can I ask why a member of PAC was not on that panel for interview?
Any other member wish to speak? Chief Minister.
Thank you, sir. I thank the Deputy for her question. I don't know why they were not, just in the same way that I was not. It was a panel made up of officials, and members will see who were on that panel, but neither the chairman of PAC nor myself were on that panel. I'm not sure whether the subject was approached or not. It's some time ago now. Thank you, sir.
Members in favour of the proposition kindly show. Those against, the proposition is adopted. We now come to the Draft Proceeds of Crime Miscellaneous Amendments Jersey Regulations 2016 P86 Appointed Day Act lodged by the Chief Minister. I ask the greffier to read the proposition.
Draft Proceeds of Crime Miscellaneous Amendments Jersey Regulations 2016 Appointed Day Act 2000. The States, in pursuance of Regulation 5 of the Proceeds of Crime Miscellaneous Provisions Jersey Regulations 2016, have made the following act.
Chief Minister.
So I'd like to ask Senator Ouzef to act as rapporteur, as he brought the initial legislation and it falls within his remit. Thank you.
Senator Ouzef.
Thank you, sir. So this is the appointed day act for the draft proceeds of crime miscellaneous regulations, and the underlying regulations were passed by the Assembly on the 15th of June. I'm sure members will recall those regulations, and they concern, of course, the important issue of virtual. Technologies failed me just when I look up. They concern the issue of virtual currencies. Members may find it slightly unusual that we've got an appointed day act for regulations. However, this was done to ensure that the subordinate legislation in the form of two orders would be ready to be made, and that the Financial Services Commission, who will receive the notifications and registrations of those carrying out virtual currency exchange business, are ready to receive applications. I'm happy to confirm to the Assembly that the subordinate legislation in the form of those two orders have been prepared. JFSC are ready to begin receiving notifications and registrations for the 26th of September 2016, subject to the states passing this Appointed Day Act. They will be, of course, made in the normal way, and I will ensure that the scrutiny panel has those orders that they've been dealt with so that hopefully they're happy and the order will be made in the usual way. If adopted, the Appointed Day Act will bring all of these regulations and then the orders, once they're done, into place. Of course, I'm not going to go into the detail of what this is all about because we've already discussed it, but I think that it's probably just worth saying just two or three things. Members will be familiar with the focus that this government and other governments around the world have been focusing on fintech. So members will be aware that there is a huge opportunity in the post-Brexit world, even greater than ever in fintech. And I was very pleased to be considering a lot of these things with Deputy Wickington in Estonia just last week and seeing how Estonia has moved ahead in the area of fintech. Technologies are being developed, have massive economic implications for Jersey as an international financial centre and for the world at large. Ultimately, the technologies that this legislation will bring into effect will revolutionise, literally, the way that we bank, invest, make transactions, and the ways that companies raise money. This legislation is one of a whole series of pieces of legislation, but I would say that ours is better almost, as I said in the original regulations, ours is a world first, and it will lead to new products, new services, new lenders, and many new opportunities. And now the Treasury Minister's here, new income for the Treasury, which is going to, I'm sure, help. Virtual currencies can be significant building blocks of a modern digital economy. The introduction of an appropriate and proportionate regulatory regime that works, that is safe, is intended to encourage confidence and innovation whilst maintaining our high standards. These regulations demonstrate a piece of really innovative legislation, combining our experience in the area of financial services with innovation in technology. It is the example of melding finance and digital. And I'd like to conclude by saying that this is a real important milestone in the development of Jersey's digital and fintech journey. And to note that as the person with responsibility for financial services and digital, I look forward to working and continuing with further such legislation. I therefore would like to propose the principles of the proposition, sir.
Proposing the Appointed Day Act, I think.
Sorry.
Yes. Seconded?
Yes, sir.
Does any member wish to speak? All those in favour of adopting
Appel, please, sir.
the appel is called for. Invite members to return to their seats. The vote is on whether to make the Appointed Day Act in relation to the draft Proceeds of Crime Miscellaneous Amendments Jersey Regulations 2016, and I ask the greffier to open the voting. If all members have had the opportunity of voting, I ask the greffier to close the voting, and I can announce that the Act has been made 44 votes in favour with 1 abstention.
The one is, please, sir.
Greffier?
The member abstaining was Senator Ferguson.
Thank you.
If I think I can get away with doing this one on blocks, the two draft.
We've just adopted the Act.
Oh, right, okay, fine. I've got my note is incorrect. I apologise. All done then. So thank you very much.
Chairman.
Yes, thank you, sir. The proposition for future business is as per the supplementary order paper with the addition of the two amendments to the medium-term financial plan, which were lodged yesterday. The important thing to mention to members is that we start the next meeting on Monday, the 26th of September at 2:30 to take questions and any statements. Otherwise, the business is as per the order paper. I would say that the next meeting with the medium-term financial plan is likely to take the full 3 days. In other words, Tuesday, Wednesday, and Thursday. Has the potential to go on longer, but hopefully not. If it does, we'll have to consider a meeting the following week. But because I think there's 13 amendments, depends how many are accepted and how long people wish to debate it. But certainly the 3 days, I would suggest, would be appropriate to make sure that we reserve. So, thank you.
Thank you. Very well. Members may know already that our usher... I'm sorry?
Sorry, just before you speak, sir, I just wanted to remind members that there's a briefing in the members' room of the Société, actually downstairs today, during lunch. Sandwiches will be provided, but CCA are going to be explaining their approach to the MTFP and public sector reform. I'd be grateful if members would attend. Thank you.
Over here, your words were not quite heard, so perhaps you could repeat them. Minister, please.
With pleasure, sir. There's a CCA briefing in the members' room downstairs this lunch, and I hope that members will attend to hear about our approach to the MTFP and public sector reform.
Thank you. With sandwiches, Senator. Go back to where I was. One of our ushers, John Ole, is due to retire on Friday. He's sitting here in the chamber. He's well known to us all. He joined the States as and the court as an usher in March 2000. So he has been helping us for approximately 16 years, slightly more than that, after some years in the private sector. He certainly has been very useful in the court as well. He has acted as a minibus driver when the court went up to Dautre in 2001. And indeed, the greffier of the States found him very useful to pass contracts on a Friday afternoon for that purpose. I'd like to take the opportunity publicly of thanking him for his help. He has a lightness of touch which diffuses difficulties wherever he goes. He's routinely polite and cheerful, and has an engaging, perhaps even impish sense of humour, which all of us have suffered from time to time. I'm sure I speak for all members in saying we will miss him in this chamber, and we wish him and his wife a long and healthy retirement. Still got to pick up the mace. The States now stand adjourned until 2:30 on the 26th September.